In 1942, the United States government fined an Ohio farmer for growing wheat on his own land to feed his own chickens that never left his property. He fought it all the way to the Supreme Court, and he lost, unanimously. And see, that single loss handed the federal government a power so broad that legal scholars still argue it has no real limit. See, this wasn't just about one farmer's wheat. The legal principle the court established that day is the reason the federal government can tell you what you can't grow in your own backyard, what substances you can put in your own body, and even some argue mandate that you buy health insurance. It all traces back to 239 bushels of wheat in Dayton, Ohio. The Supreme Court voted 9-0. Not one single justice dissented, and this decision has never been overturned. Stay with me though, because by the end of the video, you're going to understand exactly how a chicken farmer in Ohio changed the legal foundation of almost every single federal law that governs your daily life. Quick note before we go any further, nothing in this video is legal advice. This channel covers laws and court cases for educational purposes only. If you have a specific legal situation, please talk to a licensed attorney in your state. All right, let's get into it. Here's a question most people have never even thought about. How did the federal government get the power to tell a private farmer how much food he could grow on his own private land? To answer that, we need to go back to 1941. See, in 1941, America was limping out of the Great Depression. Wheat prices specifically had been catastrophically unstable for a decade, sometimes crashing so low that farmers couldn't cover their costs, sometimes spiking so high that families couldn't afford bread. To fix that, Congress passed the Agricultural Adjustment Act of 1938. The idea was simple: control supply, stabilize prices. Every farmer got a quota, a specific number of acres they were allowed to plant. And here comes Roscoe Filburn. He was a small Ohio farmer who raised chickens, dairy cows, and a bit of wheat on the side. The federal government told him he could plant wheat on 11.1 acres of land. In 1941, he planted 23 acres, nearly double his quota. The extra wheat produced 239 bushels. He didn't sell a single kernel. He fed it to his livestock, grounded some into flour for his family, kept some as seed for the following year. The government fined him $117, roughly $2,300 in today's money, and he refused to pay it. See, Filburn's argument was very straightforward. How can the federal government regulate something that has nothing to do with commerce? His wheat never entered any market, it never crossed state lines. He grew it, he used it, it stayed on his farm. The district court agreed with him. The appeals court agreed with him. Then it went to the Supreme Court. Here's something the government doesn't advertise. The entire constitutional authority for most federal regulations comes down to 3 words. Just 3. Among the several states. That's it. That's the Commerce Clause. See, Article 1 of the Constitution gives Congress the power to regulate commerce among the several states. For most of American history, that was read narrowly. It meant actual trade crossing state lines, goods moving from Ohio to Kentucky type stuff, ships carrying cargo between ports, and what it clearly did not mean was a farmer growing wheat in Ohio for chickens in Ohio. That was purely local. The courts had said so for decades. But see, by 1942, the Supreme Court had been completely transformed. Franklin Roosevelt had appointed 7 of the 9 sitting justices, after threatening to pack the court with 6 additional members if they kept striking down his New Deal programs. The court that had been a firewall against federal overreach in the 1930s was gone. A new court, loyal to a much broader reading of federal power, was ready to hear Roscoe Filburn's case. See, Filburn sued Secretary of Agriculture Claude Wickard. That's why the case is Wickard versus Filburn, not the other way around. The district court sided with Filburn, the appeals court sided with Filburn, the Supreme Court, however, took the case. And on November 9th, 1942, everything changed. What if I were to tell you the Supreme Court agreed that Roscoe Filburn's wheat had essentially 0 effect on the national economy, yet they regulated him anyway? That's exactly what happened. And the legal theory they used to do it is still the most powerful tool in Congress's regulatory arsenal today. See, Justice Robert Jackson, writing for a unanimous court, made a deceptively simple argument. Yes, Filburn's wheat never crossed state lines. Yes, his individual impact on the wheat market was trivially small. The court actually acknowledged that in the decision. But see, here's where it actually got dangerous. Jackson said that if you imagine every farmer in America doing what Filburn did, the aggregate effect on the national wheat market would be enormous. See, millions of farmers growing their own wheat means millions of farmers not buying wheat on the open market. Less demand destabilizes price. The entire purpose of the Agricultural Adjustment Act defeated. So Congress has the power to stop that, which means Congress has the power to regulate Filburn individually, even though his individual contribution was, by the court's own admission, trivial. This became known as the aggregation doctrine. It doesn't matter that your individual action has zero measurable effect on anything. If enough people like you did the same thing, it would matter. In that hypothetical collective impact, things that haven't happened yet, involving people who aren't you, is enough legal justification for the federal government to regulate what you personally do in your own backyard. Legal scholars have noted that under this standard, it is nearly impossible to think of any human activity that Congress cannot regulate. Here's a question. If marijuana is legal in your state, like fully legal with licensed dispensaries the whole 9 yards, can the federal government still arrest you for it? The answer is yes. And the reason why they can goes back to that wheat farmer in Ohio. See, the case has never been overturned, and in the 80 years since, it has been cited directly to justify some of the most sweeping federal legislation in American history. Let's start with one that will hit home for a lot of you guys. In 2005, the Supreme Court decided Gonzales versus Raich. Angel Raich was a California woman with a serious documented medical condition. Her doctor recommended marijuana. See, California had legalized medical marijuana. She grew her own plants in her own home, consumed it herself, and gave it to absolutely nobody. The federal government still said that they could prosecute her under the Controlled Substances Act. She took it to the Supreme Court, and the court ruled 6-3 against her, citing Wickard versus Filburn directly. Her homegrown marijuana, the majority said, was legally identical to Filburn's homegrown wheat. It could affect the national market in the aggregate. Homegrown supply reduces demand for commercial product. That's enough. Federal law does apply. And that is the precise legal reason why marijuana remains a federal crime today in all 50 states, even where state law says it's completely legal. What if I told you the same legal theory used to find a wheat farmer in 1942 was also used to justify making you buy health insurance in 2012? Because in 2012, the Supreme Court took up the Affordable Care Act, or Obamacare, in NFIB versus CBLS. One of the central arguments for why Congress could require Americans to purchase health insurance leaned on the Commerce Clause reasoning that Wickard made possible. The government's position is simple. People who choose not to buy insurance still affect the insurance market. They drive up costs for everyone else when they seek emergency care. Their individual decision, aggregated across millions of uninsured Americans, has a substantial effect on interstate commerce. For 53 years after Wickard, not a single federal law was struck down under the Commerce Clause. 53 years. Then, in 1995, something finally changed, and it's worth knowing about, because it tells you exactly where the limits are and exactly how narrow those limits turn out to be. In the United States versus Lopez, the Supreme Court struck down Gun-Free School Zones Act, a federal law that made it a crime to carry a gun within 1,000 feet of a school. Chief Justice Rehnquist, writing for a 5-4 court, said there have to be some limits on the Commerce Clause. Carrying a gun near a school is not an economic activity. You can't just claim everything connects to commerce. It was the first rollback of federal Commerce Clause power in over half a century. In 2000, United States versus Morrison went further, striking down parts of the Violence Against Women Act on the same grounds. Violence against women, the court said, is not inherently economic activity, even if it has economic consequences. The aggregation principle only applies to economic activities, not to everything under the sun. But here's the critical thing. Lopez and Morrison didn't overturn Wickard. They created a narrow exception. Non-economic activity can't be aggregated, but anything involving production, consumption, or the pricing of goods, completely wide open. Wickard stands. The aggregation doctrine for economic activities is as strong today as it was in 1942. And this is where this genuinely gets complicated, and where Americans across the political spectrum reach very different conclusions. Conservatives and libertarians argue Wickard destroyed the constitutional limits on federal power and created a government of unlimited authority over private life. Many progressives argue the ruling was entirely necessary, that without this broad Commerce Clause interpretation, the federal minimum wage, civil rights law, environmental protections, and the safety net couldn't legally exist. Both sides are making real arguments. The honest answer is that both can be true at the same time. Roscoe Filburn was fined $117 for growing wheat to feed his chickens. He thought the government had overstepped, he fought it, he lost, And in losing completely unintentionally, he handed Congress a legal tool that had been used to build the modern regulatory state, for better or for worse, depending entirely on who you ask. And which regulation is on the table? That's the thing about Supreme Court decisions. One farmer, one ruling, 80 years of consequences. Did this change how you think about federal power? Drop a comment. I read every single one. Subscribe if you want more cases like this every week.